Okay, well, thank you so much to everyone for joining us today. Welcome to our webinar, Estate Planning 101 Basics, hosted on behalf of Merhab, Robinson, and Clarkson. Paula Clarkson and Cassidy Russell will be presenting to you today, and you will all have an opportunity for a little question and answer after the presentation. We do kindly ask if you could please submit your questions in the Q&A feature, and if you have any technical questions, you can go ahead and put that in the chat. That'll go directly to me. It looks like mostly everybody's logged on, so we can get started shortly. Okay, so here is a bit about our firm and our firm's practice areas. We are business and estate planning, and that's our specialty. Today, you'll be hearing from our attorneys, Paula Clarkson and Cassidy Russell. As you can see here, they both do estate tax planning, and our firm also does business. Our attorney, Paula Clarkson, she's been practicing estate planning for more than 20 years. She's a certified specialist in estate planning, probate, and trust law, and she has a specialization in an LLM in taxation. Our associate attorney, Cassidy Russell, has earned her Juris Doctor at Chapman University in 2014, and she has been practicing estate planning for 8 years. Her area of specialties include estate planning, trust administration, and probate and conservatorships. So without further ado, I'll go ahead and let them take it away.
Good afternoon, everybody. Today we're going to talk about Estate Planning 101 and just the basics of what is estate planning. A lot of people are confused about the different elements and what it actually covers. When we talk about estate planning, we're talking about planning for your incapacity as well as end-of-life decisions, as well as transferring the assets when you pass away. So it could be, accumulating the assets, preserving them, transferring them either during life or at death. Take into consideration if you have minor children, beneficiaries that have special needs, how you want to transfer your assets to people. We also look at all of your tax situations because there are income tax consequences, property tax consequences when you transfer them. We have a federal estate tax that we need to look at. And just overall, what is your goal about leaving in a legacy as well as providing peace of mind to your family so that they're not involved with the courts when you pass away, to make it as easy as possible when you're gone or when you're incapacitated. So when we talk about your estate, we are talking about every single thing that you own, whether it be real estate, your checking, savings, money market, your investment accounts, life insurance that you own, whether you own it on your own life, you own it on someone else's life, your retirement plans, 401ks, IRAs. Every single asset that you own is included in your estate for determining estate taxes, as well as needing to be transferred upon your passing.
So when we talk about what is included in an estate plan, it is a group of documents that provide for what happens both during incapacity and after you pass away. The cornerstone document, of course, is your revocable trust, but along with that, there are others, including your power of attorney for financial decisions, your HIPAA authorization and your healthcare directive, which are both related to your healthcare, end-of-life decisions, donation of your organs, disposition of your remains, and also the ability to speak with your doctors because you do have privacy rights. Property agreements as to whether your property is considered community property or separate property if you have a spouse. And then also your will, which in the case of having a living trust, it's a little bit different than what people think of as a normal will. And then guardianship nominations. Those are for if you have minor children who would raise your children in the way that you feel they should be raised going forward should something happen to you. Okay, so there are two areas that we really focus on in estate planning, one being your healthcare and the other being your finances. For healthcare, that's where the HIPAA and the healthcare directive fall in, and you are appointing people to make medical decisions on your behalf if you are unable to make them for yourself. I've unfortunately been in this position with my own mom, and it's never a situation you want to be in, but at least if we lay out those decisions in our healthcare directive, we're providing some guidance to our agents to make decisions in the way that we would want them to be made. And then financially, with your power of attorney, that's appointing someone to make financial decisions on your behalf if you're unable to do so. Could be anything from going to the bank and paying bills, or dealing with Social Security and paying your taxes, which are all not fun things that I don't want to do anyway, but we get to appoint someone that we choose on that behalf as well.
So for those that choose not to or have not created an estate plan, the California has created an estate plan for you. And that's not a good thing necessarily. If you were to pass away with nothing in place, then your assets could be subject to probate. We're going to show you later that the limit for probate is $184,500. So generally, if you own real estate in California, you're easily above that. And the state of California explains, it has detail about what who has priority to make your decisions for you, who has priority to receive your assets, and those may not fall in line with what your preferences and guidelines are. So the court gets involved when you're alive in a couple different manners. So for conservatorship, so if you become incapacitated during your lifetime, then nobody is named to make your financial decisions for you or healthcare. So then somebody in your family or a friend would have to petition the court to become your conservator. And there's two different parts to it. There's a conservator of the person who makes medical decisions, and there's also a conservator of the estate who can make your financial decisions for you. So again, leaving it up to the judge may limit who gets appointed, and it could be someone that you do not prefer, because the priority goes generally to spouse, children, siblings, and so forth. And you may want a friend, you may prefer, professional fiduciary or things like that based on your situation. Also, when you have a conservatorship, all of your information is public. You may have heard with Britney Spears' conservatorship, anybody can go down to the courthouse, see what the assets are, because the conservator is required to file an accounting, almost every other year, detailing what the assets of the conservatorship are, what are the income that's come in and expenses and things. So it's all there for anybody to look at. And then also when we do it a conservator of the person, the documents are filed detailing why you need a conservator and your ailments. And that may not be something that you want to have in the public record. If you have minor children and you're incapacitated, then a guardianship is appointed for them. Or if you do pass away and a guardianship is appointed for your children, because we need to name someone unless they're 18 years old, it's a good idea, and we're going to explain further how to name a guardian for your child so that the appropriate person, the one that you want to raise them, has the same values about education, about money, about religion, maybe closer in locale, is important versus just someone who happens to be a biological relation, your sibling or something like that. When you pass away, as I mentioned, if you do not have an estate plan in place, then assets can go through probate. The limit's $184,500, or if the assets don't pass automatically, such as a beneficiary on life insurance or 401k, or payable on death provisions. If you have a will, your assets still go through probate. It's just your will says where they go. So the way to avoid probate altogether is to put your assets in a trust or to have direct beneficiaries on them. But as we talked about, we can't leave, $100,000, or even more to a 10-year-old, then a guardianship needs to be open for them, and the court will oversee their money for them. And then when they're 18, they get it. So depending on the amount, a significant amount of money could be spent filing those accountings every year with the court. And then when the child becomes 18, then they get all the money. And I don't know about you, but my daughter's almost 18, and I don't want her to, I would be terrified if she got $100,000, let alone, $1 million when she turns 18. It's just not going to be a good situation. So, probate again is also just completely administering the estate. It's filing the documents, listing the assets, confirming that all the debts have been paid, and then the court's authorizing the distribution. It generally in California takes about 1 year to 2 years, depending on the size of the estate and the asset makeup. It can take longer. And again, all those documents, because they're filed with the court, is all public record. So anybody can go in and check and see what's there. There are ways to avoid probate. And the way we do that is, we want to avoid it because of the time lag, because of the lack of privacy, as we mentioned. It's costly. It's usually, we estimate about 5% of the value of the estate, because the attorney fees are based on state statute and are payable based on the size of the estate. It also can draw out the timing of being able to heal and mourn from the loss of a loved one if you're stuck basically revisiting it for a couple of years.
Just commenting on the emotional aspect of it as well, having done quite a few of these probates, dealing with families going through this, it's just extra emotional also because of the nature of probate court. And very often there are probate referees that are reviewing submissions to the court and then providing notes and feedback that they want clarifications on. And we can submit the same type of petition to the same county and then get different probate notes and different things that they want clarified. And it just can be overwhelming and frustrating to try and get through it without getting delayed and continued out and having further expense and time spent. And ultimately, almost every client I have says when the probate is finally finished that they can finally grieve the loss that they've experienced. So there are some other ways to transfer property at death as well. One being by operation of law, and what that means is just based on how it's titled, it will transfer automatically without you doing anything else. So sometimes we see that with real property being held in joint tenancy, or assets that are community property going to the spouse, things like that. But also there's another way by matter of contract, and that's where we're talking about beneficiary designations or pay on death beneficiaries of bank accounts, even by operation of law, going back a little bit, bank accounts that you have another person on title with you, that would transfer to that person as well, the full value of that account. Sometimes the intention is to make sure that they would have access, but not that they would receive the entire amount. And that's where we run into some issues going forward with transferring property in that way.
One of the biggest issues that we have is assets held in joint tenancy. A lot of married couples will hold their property as joint tenants, their bank accounts, other investment accounts, their cars, and so forth as joint tenants. So this, yes, could avoid probate because the assets will transfer to the surviving spouse when one passes. However, it doesn't avoid probate when the second spouse dies, because now that spouse owns those assets. You also lose some control over it, because if one of the spouses has dementia or Alzheimer's and isn't able to sign any of the documents, the other joint tenant is unable to sell the property or get a reverse mortgage on it if it's real estate, and so forth. So there could be limitations on what you're going to do. Also, a lot of people, I see parents and children hold accounts together as joint tenants, and the parent thinks, oh, that's the way I'm going to transfer the assets to my child when I die. And when I explain to them that by holding your money in an account and putting your child on it, you've now just exposed all of your money to your child's creditors. If someone were to sue that child, their name is on the account and they can get, the creditors can access all of that money, even if you were the one that put that in there, the money in there. You can also sometimes, inadvertently disinherit some kids, because if you only put, for example, one child on the account, then, the other children don't get that asset. The child who received it, it's incumbent upon them to turn around and they would have to legally make a gift to the other children, which could cause some gift tax consequences. They could say no, different things like that could have some issues. Also, if you have a blended family, if the husband dies, leaves the joint tenant account or house to the surviving spouse, and then the surviving spouse dies and the assets go through probate, they're going to go to her heirs at law, which, are going to be her children first or her extended family second. And the husband's children wouldn't receive anything. And that's just because there is lack of planning. And that's just what the law says. So being able to plan and cover those situations is really important. Also, one of the benefits when someone dies is that all the assets that you own get a cost basis adjustment. The cost basis is basically what you paid for something. So if you bought a house for $500,000, that is your cost basis. If by the time you pass away, that house is now worth 1.2 million, the cost basis gets adjusted to 1.2 million. So then if that property is sold at a later date, we've eliminated the capital gain on the difference. And now we're only looking at the sales price minus the 1.2 million. When you have an asset that's held as joint tenancy, only the decedent's half gets that basis adjustment. You don't get 100% basis adjustment like you would if the asset was titled as community property, or what we like to do is community property, then put it into the trust. So that could have significant impact on capital gains related to the value of the property.
So in diving a little deeper into the healthcare documents that we prepare, I think most of us have probably had the experience of calling the doctor's office regarding maybe a spouse or a loved one and trying to set up an appointment, or in my case, trying to find out which allergist my husband was referred to. Mind you, I was in the appointment with him when he got the referral, and neither one of us could remember the allergist's name, and the nurse would not share with me what allergist she had referred my husband to. And even being an attorney and knowing HIPAA rules about privacy, I was so frustrated because even being in the appointment, they would not share that information with me. And that's because of HIPAA laws. We all have privacy rights associated with our medical records and healthcare. And so without a release, medical institutions aren't allowed to release your medical information to anyone else. So that's what the HIPAA release is for. It says you have privacy rights and you're willing to waive it for the people that you name listed on it. And then your healthcare directive itself is the document you use to direct your agents, also appoint them to make medical decisions on your behalf if you're unable to do so. So this can be anything from consenting and refusing a procedure, hiring and firing doctors, had to do that before too, and end of life care, donation of your organs, whether that's for transplant, research, education, we can dictate all of that, as well as disposition of your remains. Do you want to be cremated? How about burial? Where would you want your ashes spread? All of those kinds of things can also be taken care of within your healthcare directive. And having been in that situation before, your agent may not feel comfortable making all these decisions without some of these things laid out in the document in front of them. And then at least at that point, they have some peace of mind knowing that they're doing things based on what you've wanted, not what they want for you. And very commonly, the person that I would name for a healthcare directive is not the same person I would name for my finances. It's sometimes a different mindset, a different person to be able to handle tough end-of-life medical decisions than the person that can handle the money.
You definitely need someone who's going to be an advocate for you and ask those tough questions of the doctors.
Absolutely. Okay, so your power of attorney is on the financial side of things. As I mentioned, you're nominating someone to make financial decisions on your behalf if you're unable to. Very commonly in our set of documents, the same person that is your financial power of attorney agent is also your executor and your trustee. And the reason for that is they're very common roles as far as operating around the assets and making sure they're distributed during your incapacity for your care and benefit, and then ultimately after your passing to the beneficiaries that you've laid out in your plan. The power of attorney is for assets outside of the trust, while the trustee acts on assets inside of your trust. As far as the assets outside of your trust, that could be bank accounts that are held in joint tenancy, paying your taxes and calling the IRS, which is always fun and takes forever. Dealing with Social Security and their payments, that's another fun one. Medi-Cal and Medicare, as well as safe deposit box. And very commonly, access to safe deposit boxes can be very complicated. They'll even have a signature card at the bank that you have to appoint people on. So it's just an extra step in there that we want to make sure that you've appointed someone to be able to access those items if you're unable to do so for yourself. And your power of attorney is only effective during your lifetime. Once you pass away, that power of attorney is no longer effective, and that's when your trustee or your executor would be acting.
An important part of the estate plan is naming a guardian for your minor children. As we talked about earlier, if you were to pass away or become incapacitated and your children are minors, we need someone to raise them for you. Looking at your values, if for religion, school, location, and so forth. And we have people that name family members. We have people that name good friends that they consider family. So if you don't name someone directly, then the court will have there's an order of priority. You know, it's going to go to your parents, to your siblings, nieces, nephews, grandparents, cousins, and things. And again, those may not be the people with the same type of values that you have and preference that you want. Also, there could be people, you know, this goes back to the checks and balances that Cassidy mentioned. You know, the person managing your money, you might want a different person raising the kids so that they're working together to determine, you know, how much money should be spent for the children, as opposed to who's in charge of the children gets to spend all the money, and looking for that. So you can split up the duties as well to determine what is best for your children. So let's start with also what your will is. Okay, the will, we always have a will. Even if you have a trust, we want you to have a will. So the will basically just says, here is who I want to be in charge of my estate, which in the will it's called an executor, and where my assets go. So if you have no will, no plan, your assets are going to go through probate. If you have a will only, your assets go through probate, but you get to say where they go to and nominate your person. So that's a big difference that people forget. They think, well, I did a will, so I don't have to be involved in the court. And that's not true at all. You're going through the probate process. And then our preference is that you actually have a will and a trust. So the reason to do this is put all the assets in the trust that you're allowed to, your real estate, your bank accounts, your brokerage accounts. And the will is there just as a backup. We actually call it a pour over will. And when you have a trust, your will say, if anything has to go through probate, put it in my trust. And most of the time when we have a full estate plan and we have a trust, the reasons that we're using the will and going through probate is because after we did the plan, someone opened a new account or they bought a new piece of real estate and forgot to put it in their trust. So, or what we see a lot is people will name maybe just their spouse is a beneficiary on their life insurance policy or retirement plan and fail to name a backup. So those are things that we're always talking to our clients about is although just that asset, for example, the life insurance policy benefit would go through probate and ultimately get put in the trust, why would we waste that time and energy when it's as simple as updating the beneficiary designation? So, you know, for example, like on life insurance policies, I usually just say, name it to the trust from day one. Then we don't have to worry about what order anybody dies. The assets are in there and your trust will detail who all the beneficiaries are.
Okay, so one of the things that always comes up is whether or not people actually need an estate plan, even to the point where I know DIY is very popular right now, do it yourself anything. And I fancy myself a do it yourselfer as far as maybe some woodworking or some gardening, but I probably wouldn't do it myself on, I don't know, business planning, because I don't know a lot about how to build a business. I don't know the legal documents required. I'm sure I could look into it, but probably should get some advice about how to do that. So, what situation should you be in which you should probably do a bigger plan than maybe just a simple handwritten will or something like that? If you have assets over the probate threshold, which is 184,500, you probably should do an estate plan that has more than just a will. You should also consider it for young adults. When people turn 18, they then have their own rights to privacy related to their health care. They all have their own legal powers. They're in control of their own finances. So when your child turns 18, they go off to college and they have a wonderful time, and say they have an accident. Someone calls you in a panic saying, so and so had an accident and they took them to the hospital. Well, you could call around all over where they're at, and hospitals technically aren't supposed to release any information to you because of their privacy rights if they're over the age of 18. So for young adults, we also want them to have a foundational plan. And in that foundational plan, we have a healthcare directive, a HIPAA authorization, and a power of attorney so that we can have access and help for those young adults. But also maybe for an older adult. Maybe they are on a fixed income, they're living in senior care or something like that. They should still have a power of attorney, a healthcare directive, and a HIPAA authorization for those to make decisions on their behalf if they're unable to do so. I look at this for maybe your ailing grandparent or something like that, just to be of assistance and have them appoint someone to be able to help them when they need it. And then if you're under that threshold, maybe you could get away with just the foundational plan. I tend to think that we all should have a will for anything that we have so that we can dictate who it would go to, even if it's minor amounts. If you do have minor children, it's great to talk to an attorney, talk about those guardianship nominations, how they would receive assets. If you're under 18, you're not legally allowed to manage money. That's where also the probate court could get involved. Also, beneficiaries with special needs. And I know this is kind of a broad category, and most people think of young children, maybe someone with Down syndrome, something like that. But also, my mom's considered a special needs beneficiary. She has some health issues, she's disabled, and she receives Social Security disability income. So for her, if she were to receive a substantial sum of money, actually only more than $2,000, it could disrupt her governmental benefits. And while maybe those income benefits aren't that great, the medical care that someone receives from governmental benefits is substantial. And to disrupt that would cause major problems in her life. And so we can plan for them to receive assets in a very special way, in a protected way, so that we don't disrupt those governmental benefits. So those are a few different considerations where you may want to talk to us rather than do your own estate plan or just do a foundational plan.
When you have those, like Cassidy was saying, the young adults that are going off to college, they may have a bank account with, say, $10,000 in it. If you're under that $184,000 limit, the state of California says where those assets go. So when we're talking about your children, if they have a bank account that has $5,000 or $10,000 in it and they pass away, after waiting 40 days, the parents would be able to collect that. So we call it a small estate affidavit. You would never open a probate for something until the assets exceed 184,000. And that number is cumulative. So you could have 5 assets that total up to 60,000 and you're under the limit. Or you could just have, 2 assets that total together 200,000 and now you're over the limit and both of those assets are required to go through probate. So we've been talking about a trust. So let's talk about what actually a trust is. It's just an agreement that you put together and you're saying where the assets go. So there are actually, 3 parts to the trust. The one is the person who creates it. That's you, and it's called the trustor. Then there is the trustee, who is the one that's in charge of managing the assets. Generally, that's going to be you until you're incapacitated or you pass away. And then there's the beneficiary. So again, usually you're the beneficiary of your own revocable trust, maybe your spouse. But then when you pass away, it's probably your children or other people. So it's basically a document saying, I'm putting my assets in here. Title is held as, me as trustee of my trust. And as long as I have capacity, I'm managing the assets. If I lose capacity, there is a successor trustee named that then can take control of the property and, pay my bills, maybe need to sell things because I need to go into assisted living or I need additional income. But the trustee is the one that you would trust to make those financial decisions for you, as well as administer the assets after you pass away. So it's important, one, to avoid probate. But as we mentioned earlier, if you have minor children, so, you don't want to leave assets, substantial assets to a minor, because then a guardianship of the estate is opened and the child receives that money when they turn 18. So that could be a problem if the child is not financially mature at that point. So especially if they've already lost their parents, they might not be in a good position to make those appropriate financial decisions. Or if you have strings attached, you might say you don't receive any money unless you go to college, or things like that. Now, the trustee can use the money to pay for the children. The trustee can work with the guardian to give them money to pay for private school, to pay for soccer, dance lessons, things like that, study abroad. And it's a good idea, when the child then turns 18, the trustee is working with the child as the beneficiary, saying, okay, what are your needs? You're going to school, the trust will pay the tuition. Okay, you need money to live on for a few years, while you're in school. The trustee can work with the beneficiary to child to make the appropriate budget so that, the 18-year-old doesn't say, well, I want a Ferrari, or I want a motorcycle, or I'm choosing not to go to college. I'm going to travel the world because I have this trust fund. By allowing somebody else to be the trustee, you kind of can protect your child from themselves and use some of the strings maybe to pass along some of your values that you want. And you can put whatever you want. I've had clients say, if you earn X amount of money, you will be distributed X amount of money from the trust. Or if you make X charitable deductions every year, there are charitable, gifts, then the trustee will, can give you distributions and things. Depending on what legacy and values that you have, you can kind of guide them if you'd like to. As Cassidy mentioned, having a trust is really important for people with special needs, so that we can protect that money from them. Or in some cases, they're just not financially or emotionally mature in order to manage that money. A lot of times until kids are, maybe out of college or, mid-20s, 30 years old, it might not be a good idea to leave them a substantial amount of money, because they just don't have the maturity to know what to do with it, often until they have their first job, they start paying bills and understand, what is involved. Also within your trust, you don't have to name just your kids. You can name charities, you can name your friends, you can name lots of different things and set up a legacy for what you want and how you want your assets to be provided. And when we look at the trust, we always, it's funny because people always are like, I didn't think that far, because we're always going, well, what if that person died? I fear leaving, $10,000 to a friend. Well, what happens if that friend dies before you? Where does it go? And you're always having to look the next couple steps, because we don't know what order anybody's going to pass away or what the situations are going to be. So we want to encompass that. But we also want to look, the good thing is when you have your power of attorney, your healthcare, your trust, your will, they are 100% revocable until you become incapacitated. So as your life changes, whether it's tax laws, your family situation, the kids are now adults and maybe we put them in charge, or, there could be falling out with people. And you can change the beneficiaries around, change the trustees around, as life fluctuates. So a big part of estate planning is also tax planning. So as I mentioned before, we're looking at capital gains tax. We're looking at that cost basis in the property. Getting that step up when somebody dies can be significant when we're looking at tax planning. I've had many clients that, maybe mom needed to go to assisted living, and we're making the decision of, do they need to sell the house now or can they wait? And oftentimes, especially if mom bought the house in the 70s or 80s, there's going to be substantial capital gains if that house is sold while she lives. But if they have the ability to rent it out and then perhaps wait until mom passes to sell the property, they can reduce the capital gains on those assets. And you get that basis step up on real estate investment accounts, if you own business interest, all those things except for your IRAs and 401ks, because those have different tax issues related to them. There's also property tax issues. A couple of years ago, the citizens of California voted in Prop 19, which substantially changed the property tax field when someone dies. So now in most cases, when property is transferred from parent to child, when the parent dies, the property tax is going to be reassessed and now be based on what the value is when the parent died, not what the parent bought the property for. And I have several clients that, their parents bought the property in the 70s or 80s, and they're paying property taxes. Even with the Prop 13, little increase every year, they might be paying property taxes on $50,000 or $75,000 a year, but that property might be worth $2 million. So when the parent passes away, that amount is going to jump. Now, there's a little bit of an exclusion if it's the parent's residence and the child moves into the property and makes it their residence within a year. So it gives you a little bit of a break, but there still could possibly be some reassessment. We always want to look at the estate taxes and go through those. And I'm going to go in detail on the next slide. We have a federal estate tax, and then you have to look to the state. Fortunately, one of the only taxes that we do not have in California is the estate tax. But if you own property in a different state, that property in that state might be subject to state tax, and you might have to deal with that. But if you own everything in California, then we only are dealing with the federal tax. And then we also have gift taxes. If you make a gift during your life, then it reduces the amount that you can give away at your death. Sometimes that's a good thing and helps transfer and get some of the appreciation to the next generation. So currently, during your life or at death, you can give away $13,610,000. So if you give it away at death, it's called the estate tax. If you can give it up to 13.6 million during your lifetime, and so it's considered a gift. So, for example, if someone were to give away $2 million today, they are using some of their gift tax exemption, which means that they don't pay gift taxes, the recipient does not pay gift taxes, and then it just reduces. We take that $2 million off, and when they pass away, they can now only give $11.6 million. And the numbers are a little wonky because Congress, they get adjusted for inflation periodically, usually every year. If your estate happens to be larger than the exemption amount or what you have remaining on your exemption amount, everything above that currently is taxed at 40%. And that 40% is due in 9 months after you pass away. So that's something we always need to look at and make sure that there isn't, we have to do a fire sale or anything to come up with the money to pay those estate taxes. We have another tax called GST exemption, and that was put in place there were smart people that said, wait a minute, if I give the assets to my son, it's subject to estate tax. Then when my son dies and gives it to his son, we're subject to estate tax. Why don't I just give it to my grandson and my family saves money? So in that case, they have skipped a generation. But Congress got smart to that, and so they've set up what's called generation skipping transfer tax. So the limit for that, the exemption, is 13.6 million. So the bottom line is you can transfer 13.6 million to whomever you like during your life or at death, and you're going to be free from tax. Once your estate is above that, then we need to look at some of these other issues. Now, I know most people are thinking, well, 13.6 million is a substantial amount. And if you're a couple, that's a little bit over $27 million. But everything isn't as good as it seems, because the law that's put in place increasing this exemption is going to expire in January 1st, 2026. The estate, GST, and gift exemptions are dropping down to $5 million. They will be adjusted for inflation over the last 10 years. So the numbers that I've seen, that is everybody's estimating it to end up at about 6 to 6.5 million per person. So that is a significant drop if, you know, if your estate is above that. But there are things that we can look at with the planning to deal with that. So I'm going to give you over to Cassidy, and she's going to talk about what happens if you're a single person or we have a simple test.
I don't know if it's good or bad that I don't have any estate tax problems now or in the future, but I always wish people an estate tax problem. This is an example of what a simple trust looks like, whether it's for a married person or this being for a single person, and it shows how the assets flow down and through the trust to your beneficiaries. So in this situation, we have a trust that has assets in it, and we've provided for the heirs, the beneficiaries, in what we call dynasty trusts. Sometimes you may have heard of them as inheritance trusts, different things like that, depending on who you talk to. But basically what it does is it creates sub-trusts for the beneficiaries within your document, and it provides that they can have distributions of income and principal depending on certain situations. Should it be more conservative? Should we take into consideration their other assets and income? And we can very much specify in that. And then also who manages those assets while they're in trust for them. Are they their own manager because they're, say, 30 years old and financially responsible? Are they young kids and we're just not even sure when they'll be financially responsible? We can set an age at which they become a co-trustee, meaning they'll work alongside your trustee to understand financial management, understand a budget, understand what's reasonable and unreasonable spending habits. And even then, it protects those assets from creditors, divorce. I always say that we're all subject to bad luck and bad decisions. And so in order to be able to provide that protection to our family is a beautiful gift. I would love to be able to do that for myself, but the problem is we can't provide those protections to ourselves very easily. We can leave them behind for our beneficiaries in our trust. What this also does is it provides for what happens if there are any assets remaining in trust when your beneficiary ultimately does pass away. So in this case, we've got it going down to the children, and then if there's money remaining and they have children, it would go on to those descendants. So it protects it from staying in the bloodline and away from advantageous spouses, other people that may try and influence your children and things like that. So this is just an example of one way we can set up a trust for a simple trust.
If your estate is larger, or potentially a situation where there might be a second marriage with children from prior marriages, one thing that we can do is divide the trust when the first spouse dies. So in our example, we have the couple has their revocable trust, and in this situation, the husband passes, and they've chosen to divide it. We put the surviving spouse, the wife's spouse, into what we call a subtrust, a survivor's trust. The decedent spouse's assets come over into what we call a marital or bypass trust. They're basically the same thing in that they're both irrevocable. They are the decedent spouse's assets, and that the decedent is saying my surviving spouse can use them for income or principal and even manage them. But there are differences on how they're included in the decedent, in the surviving spouse's estate. So, for example, if the estate was $12 million, just I'm looking at it for estate tax purposes, we could put the survivor, in our example, so we have $12 million, husband dies, leaves everything to the wife. After 2026, the wife can only pass $6 million estate tax free. We could have a problem, and that everything above that amount, it could be subject to 40% tax. The way we save that is we say, okay, husband, your $6 million comes over to a bypass trust. Wife, your $6 million comes to the survivor's trust. And that way, the husband is using his exemption up to whatever it is. You know, today it's 13 million. So technically he could put up to 13 million of his assets, but his half is not that high. But we put it in a trust. And because it's an irrevocable trust that is used his exemption, those assets are not going to be subject to estate tax. The bypass ones are not. If we put it into a marital trust, it is irrevocable, but those would be subject to estate tax. So generally we put the decedent spouse's assets in the bypass trust. Hopefully they're going to appreciate. And then when they get passed down, when the surviving spouse dies to the children into those dynasty trusts, then we don't have any estate tax on that side. We only have an estate tax on the survivor side because she's still alive. So everything she owns when she dies is subject to estate tax. But we protect it, and we usually try to tell them, when we are dividing the estate, after the first spouse dies, let's put the assets that we anticipate appreciating in the bypass side so they can grow. And let's put assets that we anticipate being used by the survivor in the survivor's trust, such as, you know, the money for them to live on, to get, you know, pay for healthcare, pay for travel, pay for daily living, so that those assets are being used and depleted so that there is less estate tax. But then we can come down and they will get an adjustment on the basis. The downside, and I'm sorry, there is an error on here, but if the assets are in the bypass trust, they will not get a basis adjustment on the second death because they're not subject to estate tax. If they're in the marital trust, they do get estate tax. They are subject to estate tax, and thus they get a basis adjustment. So although the example I used is good for estate tax purposes, even if your estate is smaller, it's often a good idea if there's a blended family. Because if, for example, if the husband were to die and he leaves everything to the surviving spouse, if she has the power to change all the beneficiaries, she could intentionally or unintentionally disinherit the husband's children. This way, setting up the bypass or the marital trust says, you know, spouse, you get to use my assets, you get to live off them, you know, even if you have to deplete them all. But when you die, whatever's left there, I want to go to the beneficiaries that I have made to make sure that you're not perhaps giving it to a second spouse or a charity of your choice, or just somewhere that the decedent spouse didn't prefer. And again, you know, we recommend generally that you put the assets into what we call dynasty trust to stop the estate tax bleed at every generation. You do have the option to make distributions outright to the beneficiaries. We have lots of clients that do that. It really just depends on what your preference is. You know, outright or give them a little bit at stages. You know, we'll have sometimes clients will give a third at this age, you know, another third at a different age, so that they're not blowing it if they are at a younger age. So lots of different ways that we can set it up and talk about what happens, you know, when the first spouse dies, and what happens when the second spouse dies, to deal with the concerns of the immaturity, the special needs issues, estate tax issues, and so forth.
So one of the things that is of the utmost importance has to do with funding your living trust. And very commonly I have clients say, well, what does that mean? So funding your living trust is making sure that your assets are titled properly, either in the name of the trust or that they have beneficiary designations named on them. So that could be for life insurance or retirement accounts, different things like that. But all of your cash accounts, meaning checking, savings, brokerage, investment that are non-retirement, those all should be held by you as trustee of your trust, okay? And beyond that, with your real estate, that's a second step that we also have to do, is do a deed for your real property to make sure you own that property as trustee of your trust. Without funding those assets to the trust, it's an empty bucket that doesn't control anything, and it doesn't direct those assets to be gifted to your beneficiaries. And those assets remaining outside of the trust could trigger probate situations. Hopefully, maybe not enough to trigger a full probate, but maybe a small estate affidavit that Paula referenced earlier, something like that. Or sometimes there's enough assets outside of the trust that we have to do a petition to the court to say, this was an inadvertent error. It was the intention of the trustor to have this in their trust and have the probate court direct the trustee to pour those assets into the trust to be administered accordingly. So the next step with funding your trust is always very important, and it's a lifetime responsibility that as you acquire assets and change assets and things, to continually ensure that those are titled properly and your beneficiaries are named appropriately.
So one of the things that we do a little bit different than other firms is we offer a complimentary review to all our clients we do it about every 3 years. We call it the 3-year review. So we go through their plan with them every 3 years, look at the people that they've named, see if anybody has grown up, if there's any, marriages, divorces, deaths, again, if they still like the people they've named. You'd be surprised at how many times we hear that, the person they named as trustee is no longer in their life. So going through that, and we also, you want to check, we recommend our clients, every year when you're reviewing your taxes, check how things are titled, check who's the beneficiary on things, so that you're just looking at it again and making sure it is correct. But that's one of the things that we do on our 3-year review as well, because you can have the best trust there is, but if your assets are not in it, then you're still going to be going through probate and having some problems. So great. Thank you. That's basically estate planning 101. Obviously, there are changes, differences between people's goals that we can speak about directly, or your family situations. But in a nutshell, that's what we're looking at, is more for foundational, to avoid taxes of various kinds and provide the protections that you would like. So Cassidy and I are happy to answer any questions that you may have at this time.
Thank you to Paula and Cassidy for the wonderful and informative seminar. So it looks like we have some Q&A time. If you guys would like to submit any questions, please feel free to go ahead and put that in the Q&A feature. Any, again, technical questions can go in the chat, as I mentioned before. So I'll just go ahead and get started with the first question. Somebody asked earlier on, if not in joint tenancy, how do you suggest we title our home?
I'll go ahead and take that. If you have it, well, the first alternative would be husband and wife is community property, and that is something that is only available to husbands and wife. The difference between the community property with right of survivorship and joint tenancy is that it's only available to married spouses, and you get 100% basis step up when someone dies. But we still have the same issues that we had with joint tenancy of it going through probate when the second spouse dies. So our recommendation is to ultimately hold the house in your trust, because then the trust avoids probate. You detail who the manager is for your incapacity or death, as well as who your beneficiaries are. All of your real estate we recommend to hold into your revocable trust.
Okay, great. Another question I have is, if I don't have an advanced healthcare directive, who's going to be in charge of my medical decisions, and would they know everything about my medical history at that time?
That's an interesting question, and I've been in that situation. More or less, in personal experience, if people aren't arguing about who's making the decision in the hospital, they may just go to your closest relative that's there with you. But if people are disagreeing about your healthcare or anything like that, it could wind up in conservatorship court to appoint someone as conservator of your person to make those medical decisions. And if you haven't laid these wishes out in a document, then ultimately that person is the shot caller. They're the decision maker. They're going to hopefully do so based on what you would want for them. But I very commonly caution people, because sometimes people want to keep you alive because they would never want to lose you. And while that's wonderful, maybe that's not what you would want. And so that's where those healthcare directives are really, really important.
Great, thank you. Somebody asked, if I own an apartment complex and I convert it to an LLC, should I add that to my trust as an LLC?
Yes. In that situation, your property would be held in the LLC, and the LLC is your business interest should be titled in the name of your trust. So that when you pass away, the LLC is part of your trust. And just like any other entity, whether it's a corporation, an LLC, a partnership, it's owned, all of your business interests owned in your trust to provide this protection.
Thank you. Somebody else asked, how does the IRS annual gift limit compare to the estate gift limit? If I give $17K to a child now, does it count towards the $13 million limit?
Okay, so the gift and estate tax rules are kind of complicated. Currently, every year, any person can give $18,000 to anyone, and that's gift tax free. It has no impact on that $13 million limit. So I could give $18,000 to 100 different people, and it's not a problem. I don't have to file a gift tax return or report any of it. But if I give one person, let's say $25,000 in one calendar year, then I'm supposed to file a gift tax return. The first $18,000 is gift tax free. The other $7,000 to get up to the 25 would be normally subject to gift tax in my estate. And when I file the gift tax return, it takes that $13,610,000 and we subtract the 7,000. So that means that when I die, I can give $13,603,000. So it's the first 18 is free. Everything else reduces the amount that you can pass when you die. And if you've given over the $13 million limit, that's when you start hitting the 40% tax. But the recipient of the gift never has to pay the gift tax. It's the giver of the gift that pays it if they exceed those limits.
Great. And then one more question. If we are a single person, not married, how do you recommend we hold title?
So kind of a similar question as to the joint tenancy question, but as a single person, you're probably going to own it as an unmarried woman or as a single man, as my separate property, things like that we see commonly on a single person's deed. And ultimately, we run into the same probate issues. And so ideally, you would create a living trust and title it in your living trust to be able to provide it to your heirs and beneficiaries that you want to receive it upon your passing so that it doesn't go through the probate process we discussed.
Okay, perfect. So it looks like that's all of the questions that we have for today. So thank you so much to both of our presenters, Paula and Cassidy of Merhab, Robinson, and Clarkson. As I mentioned before, we do specialize in business and estate planning. So if you need to determine what type of estate plan is better for you, or if your estate plan needs to be updated, give us a call. We'd be more than happy to meet with you. Also, check out our website for additional resources. We have some really great informative articles and videos that you can check out on there. Thank you so much to everyone for joining us. We're really excited to continue hosting more webinars. So follow us on our socials to stay up to date on our newest blogs, videos, and upcoming events. And you know where to find us if you need us. So thank you so much for coming today. I hope everyone has a wonderful day.
Thank you, everyone. Have a good afternoon.
Thank you.